All right, hello guys. My name is Robert Fitzpatrick. I'm an attorney with the law firm of Redding Fitzpatrick here in Southlake, Texas. I am a disability attorney and I wanted to make my first informal YouTube video here. I'm just preparing. I'm getting ready to head down to New Orleans. I have 2 disability hearings tomorrow and just was really thinking about it would be a good idea to tell people out there just kind of the process of what happens and how long it takes before you actually can get into court. So, first things first, you have to actually apply for disability, right? So the cases that I'm going down for tomorrow, these people applied back in 2015, and as you know, it's 2017, so it takes a little bit over 2 years to get down there. After you apply, it takes about 3 or 4 months to get an initial decision back from Social Security. Statistically, that's going to be a denial, right? Because there's so many people that are applying, it's very difficult for them to get all the records that are needed and everything at the initial stage. So what happens is you file the application. They're going to ask you where you went to receive treatment for your disabilities. They're going to ask you for supporting information about your disabilities. They're going to send that down to the state agency here in Austin. They will assign it to a disability evaluator. That evaluator will then put together your case, request the medical records that are necessary, send it to a doctor. That doctor is going to review the medical records and see only what is in front of them and determine whether or not, based on that, they feel that you are disabled. Generally, at this point, like I said earlier, nobody is found disabled, or very, very few people are found disabled at this point. You'll receive a letter in the mail stating that you have been found not disabled, and if you disagree, then you can file an appeal. You have 60 days to file that appeal. Once you file that appeal, then it is assigned to another disability evaluator and another set of doctors who will do the same thing. They'll review it and determine whether or not they feel that you're disabled at this point. They'll ask for any more medical information or anything else that you can provide to assist them in finding out whether or not you're disabled. This is called the reconsideration stage. Again, at this stage, statistically, most people are still not found disabled. So you'll get that letter again in the mail that says, hey, we believe that you are not disabled. We feel that there is still work that's available for you in the local or national economy, and you are able to appeal this if you feel that we have made this determination in error. At this point, you file what is called a request for hearing. It takes about 9 to 12 months, depending on where you live, before you'll be able to get a court date. So during the time that we are waiting for the court date, we are still updating all of your medical records. We are making sure that everything is in play. We are receiving maybe opinions from your doctors to help solidify the fact that you are disabled. At this point, then you and I will go to the hearing. We will be in front of a judge. This judge is not the one that has made the determinations prior to this finding you not disabled. They're looking at it through a fresh set of glasses. They will listen to the legal arguments that we have to say, and then they will also take vocational testimony from a vocational expert. But that just means that it's a jobs expert, and they will answer questions from the judge and from your attorney about the limitations that you have and how those limitations affect your employability. At the end of the hearing, the judge will say, okay, I'm going to review everything. I'm going to make a new determination, and you'll receive that in writing. Usually takes 60 to 120 days to get that decision. And hopefully at that point, we do get the determination that we're looking for, that you are disabled. Unfortunately, if you are not found disabled at this point, then we have some more remedies. We're able to appeal that judge's decision. We take the case up to the Appeals Council. They're a higher court that's based out of Virginia. We file the appeal. I write a brief in support of our determination that you are disabled, and they will review it, and